Dear learner, welcome on this Swayam platform, and we are dealing with the course Understanding Competition Law Theory and Practice. I am your instructor Dr. Mayank Pratap, Assistant Professor, Faculty of Law from Banaras Hindu University, and we are dealing with 7th module of this particular course, and today we will take up the 4th session of this module and will discuss the regulation of combinations. This session will be focused on procedural aspect of regulation of the Competitions Act, the combinations procedure, what are the procedures regarding the inquiry into the combinations aspect, and also discuss some basic economic tools which is used in assessment of combination. So today we will discuss the procedural aspect, but just for a remind, if you remember the last session where we have discussed the merger control threshold, under which we have discussed about the act, that act sufficiently provides a threshold in terms of assets and turnover, which is required, and the mandatory notification to the combination. The act provides the revision of threshold limit, and it will happen in 2 years basically, and the government in consultation with the commission through a notification based on some factors like wholesome price index and fluctuations in exchange rate revise in 2 years the threshold limit in terms of turnover or assets. And the merger control threshold, actually this is a criteria and it will trigger a merger filing in India related either to turnover or asset in if the acquire and target in the case of individual or enterprise or the group to which the merged entity belong after the acquisition to the group. So with this, in today's session we will discuss the regulation of combination, how CCI will regulate the combination and from where this combination, the notification or the regulations aspect has started. We have discussed that there is a requirement of mandatory notification in terms of the combination. If any combination took place, there is a threshold limit, and if the combinations in terms of assets or turnover threshold limit passes or the threshold limit crossed, it is mandatory to notify that combination to the CCI, and CCI will took is as a matter of inquiry to find out whether there is any appreciable adverse impact of competition or not. So we have already discussed the conditional fulfilling with the merger transaction is held to be notifiable. Once the parties to the merger are sure that the transaction meets the threshold, it is notifiable and it has to be noticed. For the purpose of the regulation, the section 6 become important. Section 5, what we have discussed, that is about the combination, and section 6, what we are discussing today, that is regarding the aspects of procedural aspect, you can say, and that is like regulations or regulatory aspect is, that is section 6. If you see the section 6 in India's Competition Act, you will find that actually what happened, India regulate combination, whether it is merger, acquisition or amalgamation, that may be impact on competition in Indian market. And its primary aim to prevent any type of combination that cause or likely to cause appreciable adverse impact on competition within the relevant market in India. If you read section 6 with section 5, which is about the definition of combination and other provision of the Combination Act, it established a framework for regulating the combination. And the key provisions under section 6 are prohibition of anti-competitive combination, that is in section 6 clause 1. If you see section 6, it is stated like no person or enterprise shall enter into any combination which cause or is likely to cause an appreciable adverse effect on competition within the relevant market in India, and such combinations shall be wide. That means a combination is deemed void if it adversely impact competition in the relevant market, which includes the relevant product market as well as relevant geographic market. So in terms of appreciable adverse impact on competition, the assessment is important and the requirement of the assessment is done by the commission. That means CCI's assessment and its evaluation based on the factor which is listed under section 20 subclause 4. And there are so many parameters like barrier to entry, market concentration, consumer harm and so on. So this provision basically ensure the combination leading to monopoly tendencies, reduce customer choice or where it is for higher price or prohibited. So for that purpose, the first requirement is notification which is mandatory. That's why under section 6 subclause 2, it is terms like mandatory notification. It states that subject to the provision contained in subsection 1, any person or enterprise who is or which proposes to enter into a combination shall give a notice to commission in form as may be specified and in fee which may be determined by regulations, disclosing to detail of the proposed combination within 30 days of approval of a proposal relating to a merger or amalgamation that is referred in clause C of section 5 by the board of director of the enterprise concerned with such merger or amalgamation. As case may be, that means execution of any agreement or other document or acquisition referred in clause of section 5, acquiring the control referred in section 5 clause B. Means notification to the combination to the CCI is mandatory in case of combination where the meeting is up to the threshold limit under section 5 which is based on the assets or turnover. If you see the amended Competition Act 2023 which made a notification mandatory by replacing may with shall a set of 30 days deadline. That means now it become mandatory to notify within the 30 day of such amalgamation or merger, that is combination, and board approval of merger amalgamation, execution of agreement for acquisition of acquiring control. The notice must be filed in a specific form which is known as form 1 and the sometimes form B is required, that is in form 2 which is required for the detailing of the combination, and as per the regulation of CCI procedural transaction of business relating regulation 2011, that is popularly known as combination regulation. The notice under 6 subclause 2 is mandatory for combination that meet certain threshold specified in the act in such the terms of assets or turnover, and failure to give notice attract penalties. What is penalty and up to what penalty may be for the failure of give notice? If you see, for that purpose particular section 43A is important. Section 43A of the Competition Act provides that if any person or enterprise fails to give notice to the CCI under section 6 subclause 2, the CCI may impose a penalty of up to 1% of total turnover or assets of the combination, whichever is higher. In case of CCI versus Thomas Cook India Limited in 2014, the CCI imposed a penalty to the Thomas Cook India Limited on failure of notify of the acquisition of Sterling Holding Resort India Limited, and CCI held that the failure of such notification was the clear violence of the mandatory notification clause under section 6 subclause 2. There is one more important thing that is known as suspensory effect. This is under section 6 2A. No combination shall come into effect until 150 days have passed from the day on which the notice has been given to the Commission under subsection 2 of the Commission has passed an order under section 31, whichever is earlier. Like this period basically creates a suspensory regime which prohibit party from implementing the combination, that is transferring the assets or exercising control. The CCI approve it under section 31 clause 1 or approve with such modification under section 33 clause 3, and 150 days elapses from the notification date without CCI order, that is like deemed approval. That means there is a period of 150 days for which parties have to wait. Party cannot transfer the assets or cannot take control or use control on such. 150 days is required for the purpose of passing the order from CCI. Under this period, CCI may approve or CCI may reject, and whatever CCI may take the decision as per the statutory provision. But suppose in case this period lapses, it will be like the deemed approval from the CCI. And one thing that is you have to remember, earlier it was the date 210, but now after the amendment, now it become the 150 days. That means it is by the amendment 2023, which reduce the time from 200 days, 10 days to 150 days. There is another exemption clause which is important under section 6 subclause 4 and 5. The provision of section shall not apply to share, subscription or financing facility or any acquisition by a public financial institution, foreign portfolio investor, bank or venture capital fund pursuant to any convenient of loan agreement of investment agreement. And the other exemption under section 6 subclause 5, the public financial institution, foreign portfolio investor, bank or venture capital fund, which is referred under section subclause 4 of this particular section, shall within 7 days from the date of the acquisition file in the form as may be specified by regulation with the Commission the detail of acquisition, including the detail of control, the circumstances for exercise of such control and consequences to default arising out such loan agreement or investment agreement as the case may be. That means acquisition by public financial institution, foreign portfolio investor, bank, any venture capital fund pursuant to the loan or investment agreement are totally exempt from mandatory notification under clause 2 of section 6. That must file the form 3, which is the notice within the 7 days detailing the acquisition, control or consequences of default, which exempt balance the regulatory oversight with a practical need of financial institution. There is another section or another clause under section 6, that is section 6A, which is about the open market purchases. It is an additional which introduced by the 23rd, that means the amendment of 2023, and it states that the provision of section 6 shall not apply to any acquisition of share or security or any interest in other enterprise through or open or through purchase or regulated stock exchange, subject to the condition that the acquirer gives notice to the Commission in such manner and within such time as may be specified by regulation, and does not exercise any ownership or beneficial right or interest in such share or securities or interest, including voting rights and receipt of dividend or any other distribution, until the combination approves such acquisition under subsection 2A of section 6. What does it mean? It generally means is allows no acquisition. That means acquisition must be allowed or may be allowed via open market purchase or stock exchange to proceed without prior CCI approval, provided that a notice is filed to the CCI and acquirer refrain from exercising ownership, voting or dividend right until the approval. In such case, open market purchases are allowed, that means in case of the acquisition. Section 6 of this Competition Act regulate combination which include merger, amalgamation, acquisition of share, voting rights, assets or control over an enterprise that meet financial threshold outlined in Section 5. The core principle is to ensure that combination do not cause appreciable adverse impact on competition within the relevant market. If a combination is likely to harm competition, it is deemed void under subsection 6A. Means what? What is the regulation of the combination? If you see with the discussion which is going on today, there is no prohibition on any type of combination, whether it is acquisition, merger or amalgamation. The prohibition is only in the case of if such combination hits adversely the market, in relevant market within India, that means the economy of India, or the competition, or that is harmful to the consumer or prejudice to the consumer. And for that purpose, the CCI is authorized and empowered to regulate such type of combination. That's why there are two aspects. Under Section 5, the transaction, that is combination. Section 6, which is about the regulation of such combination. Section 5 states that there is a combination or any transaction which comes within the meaning of transaction like merger, amalgamation, acquisition or the assets or control over by the person or enterprise. In such case, it is important for the parties the mandatory notification in terms of threshold. That means Section 5 is just about the meaning of the combination, and that means meaning of the particular transaction which comes under the combination, and for the purpose of requirement of threshold that defines the threshold limit, and threshold limit is basically decided by the government and it has been revised particular at the gap of 2 years. And Section 6 came into the picture where the combination took place within the meaning of Section 5 and it crosses the threshold limit. That means only requirement is in case of any combination, parties are required to be notified it under Section 6 subclause 2. And when it become notified, CCI will look into the impact or inquire it as per the provision to check it out whether it may harmful or prejudice to the consumer or appreciable adverse impact on consumer or not. See one example. Suppose if two major telecommunications companies plan to merge, they must notify CCI. The CCI will evaluate whether the merger would lead to market dominance, higher price or reduced consumer choice, potentially causing appreciable adverse impact on competition, and if so, merger may be blocked or modified. The CCI for that purpose will evaluate the combination, and the evaluation of the combination will be done by the statutory provision which is for the purpose of inquiry into the case of regulation of such merger and amalgamation, and contained in the particularly Section 20, 29, 30 and 31 for the purpose to determine if they cause appreciable adverse impact on competition. Still, there are some factors like the market share or combined entity, barrier to entry for the competitor, regulatory barrier, financial barrier, technical barrier, impact on consumer, price increases, reduced choice, contribution to economic development. The CCI may approve the combination if it does not harm competition or propose modification to mitigate anti-competitive effect. That means what we are discussing today, there are three important aspects. The first important aspect is if parties, persons, enterprise or group is willing to enter into any combination agreement, whether it is merger, amalgamation, acquisition. They have to check whether on the terms of the turnover or asset, it may within the limit of the threshold. Because if in any case in the particular individual or in case of the group notification or group, it is a part of group that enterprises, in both case the threshold limit is defined, and in any case it increase or crosses the threshold limit, it must be notified. And CCI will take notice of such notification and will inquire into the matter on the parameter given under section 20. There are particular parameter and there are some procedural aspect to inquire into the matter, and will check or inquire if there is any appreciable adverse impact on competition. So it means the first step is generally combination, that means the nature of transaction determination. Second, whether the transactions crosses or within the limit of threshold limit, that means threshold limit decision of threshold limit is by the government. And what are the threshold limits? We have earlier seen in the last session, we have already discussed it. And in today's session, what we are seeing that there is a pattern of inquiry or inquiry, you can say there is an investigation procedure which is within the section 20, 29, 30 and 31. And after such inquiry, CCI may approve the combination if does not harm competition or propose the modification to mitigate anti-competitive effect. So with this today's session, if you see what we have discussed today, in conclusion you can say section 6 is about only the Competition Act 2002 is a vital tool for regulating the combination to maintain competitive market in India. Its concept revolve around preventing merger and acquisition that causes an appreciable adverse effect on competition. The objectives include protecting consumers, promoting fair competition, and ensuring freedom of trade. Its importance lies in preventing monopolies, safeguarding smaller players, and aligning with global competition standard. By mandating CCI oversight, Section 6 ensures that combinations are scrutinized for their impact on market dynamics, making it to a cornerstone of India's competition laws framework. So with this, what we have discussed in this particular session, that Section 6 is an important aspect which makes it mandatory the notification of the combination. It attracts the penalty in the case of failure of giving notice, which is specifically given under section 43A. Section 6 is about the specific period under which the combination took place. That means CCI may approve or CCI may modified order for modified, or CCI may reject, and that period is 150 days. Earlier it was 210 days, and in case if the 150 days elapsed, it will be like the deemed approval from CCI. That means section 6 is only the requirement of the regulating procedure. It generally elaborates that there is a regulation and it will be regulated by the CCI. But for the purpose of its regulation, there are some provisions on for the purpose of operation of this inquiry. So in next session, we will discuss what is the inquiry of any combination and what is the way to operate the procedural formality of the inquiry. So with this today's session, there is some self-assessment question for you. You have to look it, you have to think about this. Like, suppose, what is the primary purpose of Section 6 of the Competition Act 2002? And the answers may be one of the four, and that is, if it is for the purpose to regulate anti-competitive agreement between enterprise, or to prevent combination that cause an appreciable adverse impact on competition, or to impose penalty on enterprise for abuse of dominant position, or whether it is to promote the establishment of cartel in the market. And you have to identify the primary purpose of the Competition Act under Section 6 is one of these, or maybe one or two in combination. The answer is maybe correct. And that is under Section 66 subclause 2. The second question is, when must enterprise notify the Competition Commission of India about the proposed competition? And the answers may be within the 7 days of combination, within 30 days of board of approval, or after the combination, or in the case only if the CCI request notification. So this is for you, dear learner. Think about it and identify the correct answer. So for today's session, I am going to leave this session, and in next session we will discuss the regulation of combination, what we are discussing today, but in procedural aspect, like we will deal with the other section like 20 and 30 and 29 and whatever statutory regulations are there. So for today's, thank you.